If you're applying for a green card in 2025, you need to hear this. One small mistake could cost you everything. Thousands of applicants are being denied, and in many cases, they're being placed directly into removal proceedings. So today, we're exposing the top 5 reasons green card applications are being rejected this year and how you can avoid them. Stay with me because this isn't just a list. It's a guide that could save your case and maybe even your future in the US. Reason number 1, Affidavit of Support Problems, Form I-864. This one continues to be the number 1 cause of denials in marriage and family-based green card applications. And it's more common than people realize. Every family-based green card applicant needs a Form I-864, Affidavit of Support. This is the form where your sponsor proves they can support you financially and that you won't become a public charge. Sounds simple, right? But here's where people get it wrong. The form is complicated, and even small errors can trigger a denial. USCIS often sends boilerplate RFEs, requests for evidence, asking for documents you already submitted. Many applicants fail to properly show current income. They'll list income on the form but won't back it up with tax returns or consistent data. Pro tip: the safest and cleanest method? Include your most recent tax return. Keep all income numbers consistent across the entire I-864. Don't overcomplicate it with random pay stubs, conflicting numbers, or partial documentation. If you get an RFE for I-864, don't guess. At that point, talk to an immigration attorney because a second mistake can mean immediate denial and possibly deportation proceedings through a notice to appear. Reason number 2, filing I-485 when you're not eligible preference categories. This one is especially dangerous, and it's catching many families off guard. There are 2 broad categories of family-based immigrants: immediate relatives, preference category immigrants. If you're an immediate relative, like a U.S. citizen sponsoring a spouse, child under 21, or parent, you can usually file Form I-485 at any time if you're in the U.S. and entered legally. But if you're in a preference category, like a green card holder sponsoring a spouse, a U.S. citizen sponsoring a sibling, a permanent resident parent sponsoring an unmarried child, then your green card application depends on visa bulletin availability. That means you can't just submit Form I-485 because your petition was approved. You have to wait until your priority date becomes current. If you don't, USCIS will deny the case outright, and in many cases, you'll be sent to immigration court. And it gets worse if you're out of status, because now you're not just ineligible, you're potentially deportable. Bottom line, always check the visa bulletin and consult with an attorney before filing I-485 if you're in a preference category. Reason number 3, misrepresentation or lying on forms. This one's tricky because even unintentional lies can destroy your application. Here's a common example. You overstayed your visa, worked off the books, and now you're applying for a marriage-based green card. The I-485 and I-130A ask about your work history. Many people think, let me just say I didn't work. I don't want to admit I worked illegally. Big mistake. If you say you never worked, but your spouse tells the officer you've been working at a restaurant for years, now you've created a credibility issue. That can lead to a Stokes interview or even a fraud finding, which results in denial and potential immigration bars. What should you do instead? Be honest. Many applicants can still get approved even with unauthorized employment, especially in marriage cases. Just explain briefly. Yes, I worked without authorization to support myself after overstaying my visa. It's not a guaranteed denial. But lying? That's almost always worse than the truth. And remember, if USCIS believes your marriage is fake or that you're not being truthful, they can refer the case to fraud investigations. Reason number 4, medical exam errors, Form I-693. This one is sneaky and has increased in 2025. Form I-693, your medical exam, needs to be completed by a USCIS-approved civil surgeon, properly filled out, submitted within 2 years of signature, sealed in an envelope unopened. But people mess this up all the time. They submit an old or expired I-693. They forget to submit it entirely. They respond too late to an RFE for medical, or they use a doctor who is not on the official USCIS list. If your I-693 is missing or invalid, your entire I-485 can be denied. In the past, USCIS would often just request it. But in 2025, they're denying more cases up front if the medical exam isn't on time or properly done. Pro tip: bring your I-693 to the interview in a sealed envelope, unless your attorney tells you to file it earlier. And always use a verified civil surgeon. This one is easily preventable, but costs real people their green cards every week. Reason number 5. Inadmissibility due to immigration or criminal history. Here's the harsh truth. You could do everything else right and still be denied because of your past. USCIS is cracking down in 2025 on inadmissibility grounds. That includes past deportation orders, unlawful presence followed by re-entry, entry with fraudulent documents, certain criminal convictions like theft, fraud, assault, drug possession, domestic violence, and even claims to U.S. citizenship on job applications or benefits. Those can be fatal to your case. Many people don't even realize they've triggered inadmissibility. For example, if you were deported in 2011 and came back and now apply through a U.S. citizen spouse, your I-485 will get denied and you'll be placed into removal proceedings again. If you think you might have an issue like this, get a legal opinion before you apply. There are waivers available in many cases, but they must be filed correctly and early. Quick recap: don't let these mistakes ruin your case. Let's go over them one more time. These are the top 5 reasons green card applications are being denied in 2025. 1. Affidavit of support errors, Form I-864 inconsistencies, and missing income proof. 2. Ineligible I-485 filing too early as a preference category applicant. 3. Lying or misrepresenting, especially on work history or marriage interviews. 4. Medical exam problems, missing or invalid Form I-693. 5. Inadmissibility issues, past deportation, fraud, or criminal convictions. Each one of these can lead to denial and, more dangerously, a notice to appear in immigration court. Final tips before you file. Before you file your I-485 green card application, ask yourself, is your I-864 airtight and fully supported? Are you even eligible to file right now based on the visa bulletin? Are all your forms truthful, even if they expose past mistakes? Do you have a valid medical exam? Is there anything in your immigration or criminal history that could be a red flag? If you're unsure, even a little, talk to an immigration attorney before filing. The risk in 2025 is just too high. If this video helped you, make sure to hit like, subscribe, and turn on the bell icon for more clear and honest updates on U.S. immigration. And remember, one mistake on a green card application can cost you your future. Stay informed, stay prepared, and we'll see you next time here on BorderDrip USA.